Good morning, Your Honors. Benjamin Eisenberg on behalf of the appellant Valdano Riche. I'd like to reserve 3 minutes of my time for rebuttal. This argument will focus primarily on issues 1 and 2, beginning with issue 2, the discovery violation. The state in this case failed in its discovery obligations by choosing not to disclose to the defense a material change in the prior recorded statements of Mr. Angelo Pierre, which transformed him from a witness who would not be able to identify the shooter, other than to say that the shooter was wearing a white shirt, into a witness who would be able to, in effect, identify the defendant by his unique hairstyle. In so doing, the state engaged in the very trial by ambush and dirty pool tactics condemned by the Florida Supreme Court in Evans v. State and Scipio v. State. And in so doing, the state materially and procedurally prejudiced the defense by turning a witness who otherwise would have been favorable to the theory of defense into one that was a hostile witness that needed to be discredited.
This is, I believe, witness Pierre?
Yes, Mr. Angelo Pierre.
How would his testimony been beneficial to the defendant?
Well, to understand how it would be beneficial, I first need to get a bit into the context of the case. In this case, the state's theory was that the defendant obviously shot Mr. Donahue and attempted to shoot Mr. Pierre, who was Mr. Donahue's driver that day. The state's theory was that one of 3 other individuals at the scene, Mr. Isaiah George, Mr. Dave Croney, or Mr. Baldwin, was the actual shooter. Now, all 3 of those people, Mr. Croney, Mr. George, and Mr. Baldwin, gave very contrasting testimony regarding what happened the night before the shooting and the morning of. For example, Mr. Baldwin stated that the night before the shooting, everyone gathered together at Mr. Donahue's house, including the defendant, his younger cousin Kemberson, and Mr. George, Mr. Donahue, or Mr. Baldwin, and Mr. Croney. And during this event, the defendant showed up and showed Mr. Donahue the gun that he eventually killed him with. However, Mr. Croney testified he wasn't there that night until 2 in the morning, spoke with no one, then immediately went to sleep. Mr. George stated he hadn't been there in weeks. He showed up the next morning and nobody was there. There's very many contrasts. So this defense was focusing on the contrasts in these eyewitness testimony because there was not much physical evidence. There was no gun recovered.
Wait, let me just stop you right there. No matter what sort of inconsistencies there might have been between the witness's testimony concerning what happened the night before the murder, on the morning of the murder, you had 3 witnesses, Baldwin, George, and Croney, all testify that they saw the defendant point blank shoot the victim in the head, correct?
Correct. And that is where Mr. Angelo Pierre's testimony comes in. Because Mr. Angelo Pierre's testimony was inconsistent with theirs. Now, as you stated, all 3 of those witnesses, George, Croney, and Baldwin, were consistent, that they all wanted to place themselves in the backseat of the car at the time of the shooting. They all stated that my client, Mr. Riche, came up to Mr. Donahue, shot him in the back of the head as he entered the passenger seat, and then reached into the car to attempt to shoot Mr. Pierre. However, Mr. Pierre stated that there was only one person in the back seat of the car, which was Mr. Croney. He stated that the shooter shot Mr. Donahue, then walked all the way around to the other side of the car to attempt to shoot him. But most importantly, as Mr. Pierre stated in his pretrial statements, he stated the only thing, and he qualified his answers in 3 instances, the only thing he noticed about the shooter was that he was wearing a white shirt. Now, on the day of the shooting, the defendant, my client, was wearing a black shirt. And you know who was wearing a white shirt that day? These are the pictures admitted to evidence. That's Mr. George, and that's Mr. Baldwin. This fit entirely within the theory of defense that one of those 2 shot Mr. Donahue because both of them were wearing white shirts, and at the time going into trial, the substance of Mr. Pierre's testimony was that he couldn't identify the shooter other than that he was wearing a white shirt, and 2 people who were not in the car were Mr. George.
Let's assume that there was a discovery violation. The other aspect is you have to be able to demonstrate that the trial strategy would have been different if you had known about the evidence. And I think it's on page 14 of your reply brief. You have a litany of questions that, arguably speaking, could have been asked in a follow-up deposition if you had known.
Yes.
And what strikes me is all of those questions could have been asked during the trial on cross-examination. But the other thing is when I looked at your list of questions, I'm not sure how there was potentially some response that might have been given that would have altered the way in which you would have presented the case.
Well, does-
I mean, your questions involve, had Mr. Pierre ever seen anyone else with similar hairstyle, how many times, the people that he might have seen in the past that had that kind of hairstyle, were they good or bad people? I'm having difficulty understanding, even if you had had the opportunity to do a deposition, how the trial strategy would have been different. I mean, what strikes me is Mr. Pierre was kind of like your ace in the hole, that, the only thing he noticed was the shooter had a white T-shirt. The evidence was pretty clear your client had a black T-shirt on or some other color, did not have a white one on, and that evaporated. And but if you had taken the deposition ahead of time, that would have evaporated. So I don't know how you can say it would change the strategy, other than perhaps you would have put your client on the stand. But then the problem with putting your client on the stand is the fact that during the confession, he basically admits he went there once or twice before intending to kill the man because he put the voodoo spell on him, and he didn't follow through, so he went back the day the man's actually shot just to kind of prove to himself, I can do it. So, I don't think your client would have taken the stand based on the confession that he gave, so I'm having difficulty understanding how the defense preparation would have been different.
Well, Judge Connor, the problem with your analysis is it presupposes that the defense did not have any other options. The problem is that when you look at procedural prejudice and you look at the effect on trial strategy, the defense was never given the option to actually look into any of the avenues you just discussed, including investigation. I think it's interesting in this case, for example, Mr. Pierre met with the state attorney on Friday. He ended up testifying on Monday. What did he divulge at cross-examination? That the defense actually tried to communicate with him on Sunday, and he refused. The problem with procedural prejudice is that going into this case, the defense, if anything, would try to bolster Mr. Pierre's testimony. He was not part of this three-person group, which were all tight-knit, close friends. He was independent, and if anything, their strategy going into trial was to make him seem like the only person telling the truth, that he was correct, that the person wearing a white shirt was the one. By bringing out this revelation that he can in turn identify the defendant by his unique hairstyle, and let me just point out, this is Mr. George's hairstyle, long dreadlocks. This is my client's hairstyle, very unique puffs. That's what it looked like. Those are the pictures that Mr. Pierre was shown. The defense should have been given an opportunity to be apprised of this evidence beforehand and taken whatever trial strategies were necessary. The problem with this case is that they went into trial thinking one thing, that they want to bolster his testimony, and then ad hoc they have to do an on-the-fly cross-examination with no prior deposition, no investigation. Bear in mind, my client was charged with and now serving life imprisonment. There's no reason that the state could not disclose this information. It was material, and it procedurally prejudiced the defense. The trial court was incorrect in each of its findings. And bear in mind, I want to also address that Mr. Pierre qualified each of his answers in his prior statements by stating only. So when the state argued below that, these were just open-ended questions, well, let's look at what those were. He said, I didn't see the shooter's face. I only saw partially his white shirt. When asked, did you see the person who shot Mr. Donahue? He said, I just didn't go for details. The only thing I noticed was he was wearing a white T-shirt. And then when asked, well, you didn't identify anyone, you saw the one person that had a white T-shirt on. He said, yes, a white T-shirt, emphasizing this was not someone he knew, and they only noticed the white T-shirt. When he qualified his statements with the word only, there was no reason to question him further. Now, due to issues of time, I'm going to...
Can we tell from the record, when the state was interviewing Mr. Pierre on Friday, whether Pierre spontaneously volunteered information about the hair, or was he asked a question by the state, do you remember anything about the guy's hair?
Well, the exact statement from the prosecutor was, he said, quote, I had a conversation with Pierre on Friday. He came to the office. I hadn't met with him in a year, and asked him very specific questions as to what he saw, and when he saw it, he was able to tell me the guy had dreads. And I asked him to give me a better description of what dreads were, and he brought out these pictures I just showed you, and he was able to say, those dreads to Mr. George, and he said no. And he said, these dreads as the defendant, and he said yes. That was how it came about. There's no reason the state could not tell the defense this, and they knew that this would submarine the theory of defense. Now to move on quickly to issue 1, the Allen charge. This is the defense's position that there are two independent grounds that this is reversible error. First off, if you believe what the prosecutor said below, which in moving for the Allen charge, he specifically said that even though the jurors haven't said that they're hung, now this was in response to Juror Collins' unilateral note. Juror Collins was not the foreperson. She had stated, there was a note to the judge that said the Juror Collins would like to address the court, crying and requesting tissues. She gave a statement that she was one of the 2 jurors in the minority of the main decision being made. The other person was about to falter, wanted to go home. She was about to be 11-1 against her, and she said that she did not feel comfortable changing her mind. However, there are a few jurors that are extremely aggressive about it. Please advise.
Did she indicate in that note how the jury was split? Were they split in favor of conviction or?
She didn't say in that way. She just said, I am one of 2 that does not feel comfortable with the main decision being made.
Okay, but she didn't indicate which way the decision was
She
going.
didn't indicate one way, but she indicated that not only was there a 10-2 split, but she was in the minority. So first off, the prosecutor below, in requesting the Allen charge, specifically qualified it by saying, even though the jurors haven't said that they're hung, and he also said the jurors have not advised that they're hopelessly deadlocked. The case law from the first DCA in Armstrong, and from this court in the 4th DCA, says that the giving of an Allen charge in the absence of deadlock is reversible error.
So deal with the language in LeBron by the Supreme Court in 2001 where the Supreme Court said, this court has stated that it is recommended but not required that a trial court in the case of apparent jury deadlock give an Allen charge prior to declaring a mistrial. So the Supreme Court is specifically using language apparent deadlock. So if the judge gets a note from the jury, from a juror, saying, I'm one of 2, why couldn't the judge construe that to be an indication there is an apparent jury deadlock?
Well, there's also other language in LeBron v. State I'd like to mention, which is the second independent ground of why this is a reversible error. Even if you find that it was deadlock. In LeBron v. State, they say, for example, it has been held to be error to give an Allen charge where the jury has improperly indicated its numerical split. And that also happened in this case. So whether or not you believe, so if it's not apparent deadlock, then that is reversible error under LeBron. If it is a deadlock, then she divulged the split. She divulged not only that, but that she was in the minority. And this court in Scoggins v. State specifically enunciated the reasons why the divulging of the split was such a problem in this case. This court said in an esteemed opinion by Judge Gross, when combined with instructions such as the jury deadlock charge, disclosure of the jury's numerical division risks conveying the message that the court believes that the majority should prevail, creating the doubly coercive effect of melting the resistance of the minority and freezing the determination of the majority.
Well, what language in the Allen charge that the court gave in this case suggested that all of the jurors had to agree, such that the Allen charge would have been coercive as to this juror?
Well, I'll note first off that the standard Allen charge, which was given in this case, if you look on the Florida Supreme Court's website, it was adopted in 1981, has never been amended. So all the case law applied specifically applies to that Allen charge. We're talking about Allen charges generally. Now, if you look at it, it says, I know that you've worked hard to try to find a verdict, and it apparently has been impossible to you. Sometimes an early vote before discussion can make it hard to reach an agreement. And then they go on about that it's legally permissible to disagree. The message of the Allen charge, which is carefully tailored, is that she just divulged that she doesn't see how she's going to change her mind. They're telling you to go back and make a decision. The message that it's sending is that we're not going to help you in this case, and that we want you to go back and deliberate with these otherwise hostile jurors that you say that you're not comfortable.
But the Allen charge goes on to explain to the jury, make the suggestion that each of you should speak and everyone should listen to what's being said. So, what strikes me is you've got a juror saying, I'm being intimidated by other jurors. And the jury then receives an instruction which says, suggests that each of you should speak and each of you should listen to what the other one says. So if anything, it kind of sounds like it might be addressing her concern or issue that, I'm being intimidated by one or two jurors in this case, and the court is politely telling all the jurors, y'all need to listen to each other.
Well, I disagree in that because it doesn't say what to do after. She'd already said that she'd explained all of her concerns. She had done this before, but then the problems come with afterwards. The message that's being sent is, okay, everyone listen and explain, but then you're on your own again, which is exactly what she was at. And the case law in this case, in this regard, and I just want to point out again, in Thomas v. State, the Florida Supreme Court stated that the divulging of a numerical split is an area of critical concern. I also want to point out one last thing before I sit down, that I included a supplemental authority that the Rules of Criminal Procedure, the Florida Supreme Court amended the Florida Rules of Criminal Procedure, specifically 2.08 and 3.13, which are verdict and submitting the case to the jury and submitting case to the jury. And they were amended to add the following sentence to the instructions, quote, "If you have voted, do not disclose the actual vote in the note." And in support of this, they cited Scoggins from this court, which they said stated that knowing the numerical divisions within the jury could lead the trial judge to interact improperly with the jurors. That's what I believe happened in this case when the Allen charge was given after the split was divulged and after Juror Collins specifically stated that she was in the minority.
So had they voted at that point? Actually voted, or just she got that sentence?
Well, that's in support of my argument that it was premature. The note says what it is, and I can read it for you again. But basically she said she's one of two that does not feel comfortable with the main decision being made. It's unclear what stage of deliberations. Remember, there were two charges. There was murder and attempted murder. And that was what she said. So that was the substance of her note. Thank you.
Good morning. May it please the court. Melinda Miller on behalf of Appellee, the state of Florida. I'll start with the Allen charge, if that's okay with your honors. I just want to make from the get-go very clear that the issue before this court is whether or not it was proper to give the Allen charge. It has nothing to do with the motion for mistrial that was made below, and it seems that both below and on appeal we're mixing a number of issues together. For instance, there was been focus on how the intimidation of a juror, when in reality the sole issue on appeal is the giving of the Allen charge. Going to that, the last discussion was with regard to the Scoggins case and the numerical division and the revealing of the numerical division. I like to respectfully point out that not only was this not brought up at trial at the time the Allen charge was given, but in the motion for new trial, there was only one reference to Scoggins. It was on page 165 of the motion. It did not talk at all about the divulging of a numerical division, but instead talked about the isolation of a juror, and that was what the proposition for Scoggins was. So, in reality, the issue of numerical division has never been raised or preserved for appeal. Yes, the juror did say that she was one or two of jurors that were in the minority view, but we do not know what the view was. Also, the only thing that we have from the juror, she declined to verbalize what the problem was. She opted to write this note, and while we do know that there was something going on, I'd like to point out that she said that she was being asked to repeat all of her concerns over and over, but she said in her note, "I have been unwilling to do so," or I have been unwilling to do. So it seems that the Allen charge really was a response to this note, and it was an appropriate one. First, we know that there is a division in discussion. Secondly, we know that somebody's having trouble listening and articulating viewpoints.
But let's talk about that a little bit, because the state is the one that suggested let's give an Allen charge.
That's correct.
The defense immediately objects and moves for a mistrial, and the court decided to go ahead and give the Allen charge, but it was in reaction to a note from a juror. It was not a note that was framed in the context of the entire jury is interested in this question, and it's not a note from the foreperson. So isn't that a problem that the court kind of jumped the gun and assumed there was a deadlock? And isn't there a problem about that decision being premature?
I understand your issue, Your Honor, and it was from a single juror. But the case law says that the Allen charge is appropriate, not where the jury is, and I've heard this repeated and seen in the brief, hopelessly deadlocked. That's not the standard. The standard is if they are having difficulty in reaching their verdict, and that is clear from this note. I've cited in my answer brief, it's a 3rd district case, not a Florida Supreme Court case, a 3rd district case, Campbell, that came out recently in 2016, and in that case, the court said that it was reversible error for the trial court not to have given an Allen charge with regard to a single juror's note, and the site for that, Your Honor, is 187 Southern 3rd 577. Based on a single note that that she wasn't going to be able to reach the verdict that everybody else was being given. In that case, what happened was that she first said that she didn't think she was going to be able to agree to one of the 2 charges. And then there was a second note, then a verdict came out. She said that was not really her verdict. The court sent them back without an Allen charge. And she sent back another note that said that she had questions with regard to her duty because that she would not be able to give a verdict. So in this case, we have a juror that's saying, there appears to be a division. I'm being asked to support my position. I'm unwilling to do so. I don't know if I'm going to be comfortable changing my mind. The Allen charge was absolutely the appropriate measure in this circumstance based on there being an obvious, apparent difficulty in reaching a verdict. I recognize it wasn't from the foreperson, but it was from a juror and it was addressed by the court. If the court had chosen to simply ignore this and send it back and send the jury back, then that might give the signal that they had to reach some kind of a verdict. She had to go in there and work with the other jurors in the direction that they wanted. To grant a motion for mistrial would have been sorely inappropriate in this circumstance because if you look at her note was very simple. It was a paragraph. She said she was unwilling to give answers to the jurors about her position, which was the minority position. And while she did say, and she said she was uncomfortable changing her mind, she just said a few jurors that are extremely aggressive. She didn't say there was yelling. She didn't say there was violence. She didn't say anything about the circumstances that were making her seek advice. With regard to the Allen charge being premature, again, I'm going to point out that while the trial court did address the issue of giving of a Allen charge when a jury is not deadlocked, the specific issue of the Allen charge being premature was never raised. Nothing below was raised except a motion for mistrial. And said I would rather not give the Allen charge and gave no reason. I'm moving for a motion for mistrial because the juror is upset. In the motion for new trial, pages 164 and 165 are the only times that they even address the Allen charge, and it's wrapped up in a ball with the emotional juror and the circumstances of the deliberations. There was a sentence that said it's inappropriate to give a Allen charge if a jury is not deadlocked, but there was nothing that said, and the jury was not deadlocked in this case. If you look at the note, the jury was at a point where she's unwilling to move forward, and they were at a stopgap. With regard,
Your basic argument then is that there were circumstances surrounding the deliberations as reported by this juror sufficient to suggest a deadlock such that given an Allen charge would have been appropriate.
yes, Your Honor, that is the state's position.
In that Campbell case out of the 3rd DCA, so that shows that it's not necessary that that note come from the jury foreman, but it could come from just one single juror.
When there's an indication, yes, Your Honor.
There was only one Allen charge given in this case,
There's
correct?
only one Allen charge. It was a standard jury instruction at the time. with regard to issue 2, which is the discovery violation, or alleged.
Was there a discovery violation?
Well, the state's position is that there was not a discovery violation, because in order to be a discovery violation, an oral statement by a witness has to be a material change in testimony. And the instances where it's taken place in case law are usually with regard to recantations. I say that you stayed at my house, you never stayed at my house, then later I say you stayed at my house, but you just weren't there at that time. That would be, I believe, the Washington case.
Isn't there, though, a material change in a witness's testimony when that witness provides further identifying features of a suspect?
I have not come across that case. In fact, I cited in my answer brief Elgomari, which was a child molestation case out of this court. And in that case, there were charges. The victim didn't, in her statements and her interviews that were forensically done with the detective and child investigators, never mentioned 2 of the incidents that were alleged in the charges. In the deposition, the victim was never asked about those incidents, and when the trial came about, in opening statement, the prosecutor said, well, this is what the child is going to allege.
It wasn't a recantation, I agree, but, Pierre's testimony initially was shooter had a white shirt, and the evidence was defendant did not have a white shirt on at the time of the shooting.
correct.
Okay, so the witness's testimony would establish he's not the guy that was the shooter, okay? But then the testimony changed, and he said he had particular dreadlocks or whatever, which then all of a sudden would identify him, as I understand it, because his hairstyle was substantially different from the other 3 that were witnesses testifying. So it goes from it's not this guy to now all of a sudden, yeah, it is this guy. So it's not a recantation, but it's a dramatic 180-degree turnaround.
No, Your Honor, I respectfully disagree, and here's why. In presenting your question, you brought in evidence not just from this particular witness, but around the case, the fact that he didn't testify what the other shirts were. What we do know is this defendant had a gray hoodie on at the time. I don't know, I didn't look at the picture right before I came to remind myself, but it could have been light in color. What we have is a witness who has never said throughout the trial, and this was in both the prosecutor's closing and defense closing, this witness has never identified this defendant, ever. Continue to say, I cannot identify him, I cannot describe him, I did not see his face. And so that is the difference. If the defendant said, or if the witness had said, I can't identify him, and then came to trial and said, I can't identify him, it was the appellant, that would be a material alteration in testimony to result in a discovery violation.
If we review the record and we disagree with your analysis on that point, address the prejudice issue, because that's a very significant problem.
Certainly, Your Honor. The prejudice issue is, first of all, let me stress that the trial court did do a Richardson hearing. Both sides presented what was said by this witness and what they wanted to produce. The trial court found that it was inadvertent, found that it was trivial, and found that the defendant was not procedurally prejudiced. The trial court allowed 10 minutes for there to be discussion to get everybody together. Then there was a lunch break before they continued with the examination of this witness. Now, any questions that needed to be asked could have been asked or addressed during that time. The cross-examination of this witness was extensive, and what was revealed was basically all that, and the state submits that all that they could ever get out of this. What was revealed was that the police asked him if he saw the face of the defendant. He said no, he did not, and that the only thing that he could remember was the white shirt. The police did not ask about whether he saw hair or any other thing or any other detail. Then, and then he said he was also presented at the time with photos of I guess the ones that they use in the photo lineup where he couldn't identify, and only Mr. George, the victim's stepson, had the long dreads, and that was, he knew, he said, I know who Mr. George is, because I know the victim, I knew that wasn't him, that's why it didn't become pertinent until later that he had mentioned it. The way the prosecutor found out about the hair, and specifically, was to continue, well, you say you saw dreads, now what do you mean, and discovered that they were knobs. That's the extent of it, that he did see the top of his head, saw hair, knew it wasn't long dreadlocks. But I'd also point out, and this is something that the defense is going to have to deal with, is the only Haitian and the only Creole speaker in the car, besides the victim and the driver, both of them being victims, was appellant. And the driver, who was the second victim of the attempted murder, said that the person holding the revolver, which Mr. McPhee saw in his hand, a complete objective bystander who saw him flee, was that he spoke to him in Creole and said, I'm going to shoot you too. So that is something that went to the identification of the shooter, and it really put an absolute hole in the defense that was being played, which was, oh, you know, he was not part of the real group, and that the stepson could have very likely been the shooter. So we have his DNA on the light hood, you know, or the gray hoodie, which could be by anybody's mistake. But, you know, in addition, we have, and this doesn't go to the procedural prejudice, I do know, Your Honor, the procedural prejudice would be, what else are you going to do to further your defense? And it can't be done. And the defense did argue in closing argument that, you know, oh, he hadn't brought this up before and now he's bringing it up for the first time. I don't think that there's anything that could be done if the prosecutor called him up and said, you know, this is what we discovered. And then, of course, the state had a very strong case. It had 3 witnesses that identified him. They had Mr. McPhee, who saw this appellant in his red shorts running out of the gate with the silver revolver in his hand, and we have a confession.
Are you arguing harmless error to the
No, I am arguing it, but usually with regard to the discovery violation, you go right into the procedural prejudice in this case.
So you're saying a 180-degree turn would have been if he got on the stand and said he was wearing a dark shirt?
That would be,
Or gray hoodie or something.
or something, or if he got on the stand and said, I can identify him, or I did see his face. And that's what the case law has dealt with, our recantations.
Well, what's the difference between I could see his face and I could describe his hairstyle?
I could see his, I'm sorry?
What's the difference between I could now identify his face or as opposed to I could identify his hairstyle? Aren't they both
No, because he was never
identifications?
asked, and that was in the Algarmi case that was cited by the state in the answer brief. This court specifically stressed that just because the defense asked open-ended questions in the deposition and didn't get the response that got these additional details, didn't make it a material change or a material alteration in testimony. So if there are no further questions, the state asks that you affirm.
Thank you. Mr. Eisenberg.
If I could just have a few minutes, Your Honor. I'd just like to begin by saying I contest that this was a strong case for the state. We know from issue 1 that the jurors were splintered and divided. So it was not the slam dunk for the state by any imagination. Now, beginning with issue 1, which I just discussed, the state primary argument pertains to preservation. Now, I just want to point out that first off, the standard review in this case is set down by the Florida Supreme Court in Thomas and LeBron is whether, under the totality of the circumstances, the trial judge's actions were coercive, or the facts and circumstances surrounding the individual case combined to create a serious risk of coercion. So preliminarily, that is the standard review because when the judge gives an Allen charge, the judge has to undergo that analysis before even giving the Allen charge. So by lodging a contemporaneous objection, which the state agrees that the defense did, the judge had to undergo that analysis, and that encapsulates the totality of the circumstances. Furthermore, let's look at the objection that was made below. Trial counsel objected to the Allen charge based on Juror Collins' appearance and the tone of the note, especially her suggestion that one juror is changing her mind just to get out of the situation. She's visibly upset, and I don't think if they reach a verdict, it doesn't sound like it's going to be a verdict that is really the equal vote of every person. In other words, defense counsel was objecting on the basis that it would result in a coerced verdict. I disagree that Campbell applies to this case because Campbell is very different. First off, there, the defense counsel requested the Allen charge, not the state. And there, the single juror had indicated at multiple times, they had done a jury, they polled the jury at one point. The juror said that wasn't their the verdict. They continued on and on. And multiple times the judge instructed, refused an Allen charge and continued to deliberate. At that point, the judge had to do something, anything, whether it was an Allen charge or not, and that was the defense's request. As to issue 2, you have to understand that in the theory of defense in this case, nobody was claiming that some stranger came to the scene and shot Mr. Donahue. There are set players in this case, and when you're able to negate the 3 people that are the theory of defense, and then identify the defendant based on his unique hairstyle, which you've already seen, that is a material change in the evidence that needed. There's no reason that the state could not have turned that over to the defense as soon as they knew it. They knew the impact that it would have on the defense, and it did impact the defense greatly. And if there are no further questions, I'd ask that this court reverse for a new trial.
Okay, thank you very much. Thank you, counsel.